Welcome to the Business SOS podcast. This is Rich Sierra, president of the Florida Small Business Legal Center. This is episode 98 of the Business SOS podcast. I'm very excited that we're getting close to episode 100, as I've been talking about for the last few months. Today, I want to talk about something that has happened very often, and I have some clients that I'm representing currently and in Florida, and regarding this issue. What to do if your business or you are sued in another state? So say you live in Maryland, you live in Texas, and you get a Florida lawsuit. What are you going to do? So we're going to talk about that. I deal with several clients that live out of state, and they are, for whatever reason, they're being sued in Florida. And so it's happening very often now with a lot of, businesses doing business interstate, and you have online businesses and people placing orders from companies that are out of state. So it's happening very often. So I think it's important to talk about that today. So we talk about this scenario. Say you want to go into a distribution business, and the manufacturer happens to be in Florida. Let's call it vitamins, and I'm making this up. It's not any type of specific item, but say you want to sell some vitamins or supplements for consumers. It could be some energy supplements, testosterone supplements, whatever. The manufacturer happens to be in Florida, and you are in Texas, and you want to have a distributorship to be able to sell the product in Texas. So very likely you will have a distribution agreement from the manufacturer that gives you, say, for example, exclusive rights to sell this product in the state of Texas. Very likely that agreement will have what is called a venue selection clause. And what that means is that it will have a clause that says any disputes will be resolved in the state of Florida. Could be, say, the county of Palm Beach County, and that will be the venues, the forum where you're going to be selected, and also will tell you that all disputes will be handled to Florida law. All these very often these venue selection clauses are ignored. They're usually in the back of one of the last pages of the contract, and they're ignored. And so say a few years later, you have an issue with this manufacturer that perhaps the manufacturer gave you some defective product. The manufacturer did not give you the product that you were asking for, did not fulfill your order the way you requested it, or you paid and then the order was not provided to you. And you want to sue this manufacturer. You try to sue in the state of Texas, but then you have a contract that states that the venue selection clause is in Florida. Guess what? You only can sue in Florida based on that contractual agreement, the contract that you have with the manufacturer. Likewise, if the manufacturer has an issue with you, a legal dispute with you, then they will have to sue you in Palm Beach County, as this fact pattern, this example that I'm utilizing, and you cannot sue anywhere else, and then you have to retain counsel in Florida to represent you. This is very common. So I want to talk about that. So can they sue you in another state? The answer is yes. You can be sued where you reside, you can be sued where you reside, but also you can be sued where you do not reside if you establish what is called minimum contacts with the state. And I'm not going to go into a deep dive in legal analysis of personal jurisdiction and subject matter jurisdiction. That's a whole different law school class that we spend a great deal of time. But I'm going to give you some points to consider that you might be subject to the jurisdiction of another state, especially Florida. I'm going to talk about Florida specifically. That's where I practice. So you understand that, hey, I am entering into this contract, and I'm aware that if I do so, I will go ahead, and if there's an issue, I will be subject to Florida law, and I would have to retain local counsel in order to defend myself. So as long as you know that, that is fine. What situation that I encounter often is that people come to me, listen, I got sued in Florida. I do not know why. And I ask the question, well, do you have a contract? The answer is yes. Can I look at a contract? And I look at a contract, well, the contract has a forum selection clause of Florida, and the court is Palm Beach County, or federal court, could be the U.S. District Court in Fort Lauderdale or Palm Beach. I was not aware of that, but it's in the contract. And what I tell clients, and I have repeated in this podcast, pretty much in every single podcast, is that you have to read your contracts. You have to read the contracts, and do not just tell the attorney, yeah, read the contract for me. We'll read the contract. However, it is important for you to understand what you're getting into. If you do not understand the contract, do not sign it, or ask somebody to help you interpret the contract for you and help you answer your questions. But relying upon somebody else to read the contract for you is not going to work, because ultimately you have to sign the contract. And the courts will enforce a bad deal. Just please understand something. The courts will enforce a bad deal provided that it's not unconscionable. The court is not going to try to figure out whether it was a good deal for you, whether it's not. They're not going to do that. Okay? They don't like to get involved in business disputes or trying to interpret what the parties agreed to do based on the contract. They'll read it. Unless it's unconscionable, fraudulent, pretty much it's going to be valid. So just keep that in mind. So, what is personal jurisdiction? I want to talk about that for a minute. It's the court's power over you, or basically the court has the ability to enforce a contract with you or place a judgment. You have subjected yourself to the jurisdiction of the court. So that's what it means. How can you get yourself be subject to the personal jurisdiction of the court? And please understand, this is a very, very top level discussion. I'm not going into a deep dive here into personal jurisdiction with case law. I just want to give you some pointers to understand that if you have a situation where you have a contract is presented to you, I want in the back of your mind say, okay, what happens if there's a dispute here, if I need to go to court, where do I need to go? I want you to just keep that in mind, more of a top level situation, not go into a legal analysis of personal and subject matter jurisdiction. So I'll give you an example. Signing contracts with form selection clauses, I mentioned that already. If the contract states that you have the remaining jurisdiction is Florida in a specific county, you're pretty much in that state. So that's often that particular provision is ignored or not looked at. Now, what happens if you get sued in Florida, but you don't have a contract and doesn't have a form selection clause? That's an interesting question. So a way that you can end up subjecting yourself to the jurisdiction of the court is filing an answer to the lawsuit without raising the defense of lack of personal jurisdiction right from the very beginning. Okay, and I'm dealing with a situation presently that deals with that particular issue. Okay, and there are a lot of nuances to that, but the point is that you get a lawsuit, you live in Texas, you're being sued in Florida for breach of contract. The contract doesn't have a form selection clause. And you get upset, you get angry, and you decide to write a letter to the judge explaining everything. Okay? Or somebody helps you, which happens often, which I'm really against that. Sometimes you have other lawyers that are not involved in the case, do not want to put their name in the case. Okay? Prepare an answer and say, go ahead and file this with the court. You file an answer, which clearly was prepared by an attorney, but the attorney's name is not there. And you send it to the court. Do not raise the defense of lack of personal jurisdiction. You're in the case already. And then you finally get a Florida attorney and say, listen, I don't know why I was sued here. I want to raise defenses. I need local counsel. This friend of mine helped me out. I filed this, and which has happened to me. And my answer would be to that individual is like, well, you should have never filed this in the first place. Okay, I wasn't going to miss a deadline. There are ways to do that. That way you can mitigate missing a deadline without putting yourself in a situation that you waive a defense. So you say you file something with the court, a defense, or a letter to the judge, and not raise that defense in the first place, or reserve the right to go ahead and raise that defense, you waived it. And at that point, you are subjected already to the jurisdiction of the court. And then you got to have a Florida attorney defend the case all the way to trial, because that defense is no longer there. Okay? If you have a business and you're conducting business in the state, okay, say you have an online business, you're selling products, you're doing a lot of sales in that particular state, you're conducting business in the state, very likely the court will have jurisdiction over you. Operating websites that targeting the state, people in the state, very likely you will be subject to jurisdiction of the court. So please keep in mind that this actually could happen. Out-of-state shipping, marketing affiliates, travel agencies. If you're doing business with people in the state, very likely you will be under jurisdiction of the state. How to challenge a jurisdiction? Immediately, the first thing that has to be done is filing a motion to dismiss for lack of personal jurisdiction. This is very, very important to do that, and an attorney has to help you with that. Okay, that's something that you should do yourself. If you're a company, a corporation or LLC, you will have to do that through an attorney, with the exception of small claims. But even then, if you're thinking that I should not be sued in the state, I have no contact with the state, I have no checking account there, I have no property there, I don't do business there, and I'm dragged into court in Florida, you need to have an attorney help you with that. But there are a lot of nuances, and it's a very, very technical motion that has to be filed along with affidavits and some other documents that have to be filed in order to raise that defense properly. So it is important to do that. One of the things, especially with out-of-state service, that we look at, which deals with jurisdiction, but it's a little bit more of a collateral issue, which we look at, is how you were served. Okay, it's important to know that, because every state has different rules about service. So in some cases, you got to file I'm trying to think which state, I think it's Nevada, that you got to comply with the statute to be able to serve someone there. In some cases, you got to file you got to file a case with the state, and then you have to use obviously a local process server, but there's a process to file to serve someone in a specific state. So one of the things I look at when somebody's sued out of state, I'll start from the very beginning. How were you served? Did they drop it off in front of your house, which is not personal service? They gave it to a neighbor, which is not personal service. Okay, so you have to look at the case from the service, how the service was conducted, and whether or not the service met the requirements of Florida statute, but also the statute of the state where you reside. Assuming that was the case, then it is important to immediately hire local counsel. Deadlines matter. In some cases, in Florida, you have 20 days to file a response and I say mention response, not an answer. I want to be clear about that. File a paper with the court within 20 days. Okay? And a paper can be as simple as, if you have everything, you don't have an attorney, is filing one single piece of paper saying, I want an extension to get an attorney. Okay? Simple as that. You're not admitting anything. You're not waiving any defenses. It's simply a motion to an extension to file a response because you want to get an attorney. If you're a corporation, they can move to strike that. But by filing a single piece of paper with the clerk, okay, you avoid what is called a clerk's default. And that's significant. If you don't file something with the court within the required time period, the plaintiff can ask what is called a clerk's default. And then the clerk will issue a clerk's default for failing to file any paper within the required time period. Now then, after that's the first step to get a default final judgment. Then the plaintiff can file a motion for default final judgment and get a final judgment against you. Granted, there are steps to do that and there are ways to overcome that. But ignoring deadlines can really be devastating for your case, especially when you're out of state and you're being sued in Florida. You're already at a disadvantage because you have to hire counsel in Florida to help you. So just keep that in mind. And then hire local counsel is very important. An attorney who is familiar with the court, who practices in that particular court, who understands the rules. Every court is different. Every court has nuances. So it is important to have an attorney who is familiar with that particular court to help you. Doesn't mean that it's impossible not to represent you in a different court system. Every circuit is different. We work with same rules, but all of them have their own local rules that we got to abide by. So there are different nuances there. If nothing else, you can contact your local attorney where you live and have your local counsel help you find an attorney in Florida. Worst case scenario, local counsel can reach out to plaintiff's counsel and ask for an extension. I said, listen, we're trying to get him an attorney in Florida. Can we get an extension? And have an email confirmation of an extension that, yes, you can get an extension to file a response. So at the very least, have that, but do not ignore the lawsuit if you're being served. Now, the defense, obviously, when you're filing a motion, and again, I recommend you do not file this motion for lack of personal jurisdiction. That motion should be the only topic addressed on that particular motion. Should not be anything else, because you might deal with an issue that you're already defending the case. So, and that's something that your attorney would address that with you. In other words, do not over-litigate the case and try to basically have all your defenses all at once. If it's a motion for lack of personal jurisdiction or lack of subject matter jurisdiction, which is a different topic, which I'm not addressing today, then that should be the only motion. The motion usually includes an affidavit, a sworn statement by you stating that you have no personal contact with the state, you did not you don't have any property in the state, you don't have any business in the state, you don't have a checking account in the state, and therefore the court should not have jurisdiction over you. Say the other side opposes that and say, no, we have a disagreement here, we're not going to agree to that. Then what the court will do, they will do something called an evidentiary hearing, in which testimony is taken from you and on the other side, determining whether or not you have had minimum contacts with the state in order for you to be subject to jurisdiction of the court. So there's a cost to do that as well, and it's not guaranteed. Another option that some of my clients have exercised, say you are being sued you live in Texas, and then you're being sued in Florida. The amount of controversy, or the amount of the damages are over $75,000, and you don't have a contract which states this has to be in state court, for example. So another option that you may have is to transfer the case to federal court through a notice of removal. What that does, and that has to be done within 30 days from service. Okay. 30 days from service or filing, most likely from service, because that's when you receive the actual service. So there's a time period to do that when you can remove the case to federal court. The process is very simple. It's administrative. Excuse me. So in this case, your attorney will have to do that. I recommend you don't do it. It's just a little bit technical to do that. And so the attorney files what is called a notice of removal to the U.S. District Court. It is filed with the U.S. District Court. You open a brand new case with the U.S. District Court. All the files from the state court are uploaded to the U.S. District Court's filing, and then the case is transferred. Then you file also a notice of removal to the state court to notify the state court that the case has been moved to the federal court. And at that point, the federal court, the U.S. District Court, takes jurisdiction of the case and continues the case as if it was in Florida court. What are the advantages of that? You have the benefit of federal court. I think from my opinion, federal court is a more predictable with the extent of the schedule. That you have a more a scheduling conference that is prepared by the court, sometimes done with opposing counsel. You don't have as many hearings, but you have more impartiality to the extent that you don't have to deal with state court judges, although they will be impartial as well. But some out-of-state clients feel more comfortable with federal court. And then you can raise your defenses in federal court as to lack of subject matter jurisdiction, lack of personal jurisdiction, maybe move to a more convenient forum, maybe your district court in your state. So that's an option you have. But in order to meet what is called diversity jurisdiction, which is what I'm talking about here, then you have to be citizens from different states, which in this case, this example that I'm giving, Florida and Texas, you meet that first prong. Then the second one is the controversy. Has to be at least $75,000. If it meets that criteria, then you have that option to remove the case to the U.S. District Court, but it has to be done within 30 days from date of service. Otherwise, it is waived. So it's important to discuss that option with your attorney to see that's something you want to pursue. A benefit to the U.S. District Court, pretty much everything is done remotely. In state court as well, a lot of things are done remotely, but you don't have as many hearings with federal court, which also saves with respect to time and money. In state court, you have a lot of hearings that you have to go through, the attorneys have to go through for different disputes. In the case of federal court, the hearings are only available upon request and if the court agrees to. So pretty much the court makes decisions, what we call on paper, based on the pleadings, and the court makes a decision, makes a ruling. And if you need an oral argument, it's up to the court to agree to that or not. In state court, you can schedule that hearing if you feel that you have a dispute that you want to address, the court to address. Then in that case, you can set the hearing without the court's permission. You can just say, opposing counsel, we have a dispute here, we don't agree, so I want to go ahead and have this heard by the judge. When can we set the hearing? Here are the dates. So it's very different. The only time you have to appear, which this will be in the case of both sides, whether it's state or federal court, is that you would have to appear for trial in person. Unless the court agrees otherwise, pretty much in person, you will have to appear in person for the trial. Whether it's a state or federal court, you'll have to do that anyway. For depositions, that can be done remotely via Zoom. You don't have to, be there as well. You cannot be compelled, or you can be compelled, but that's a different conversation. But for the most part, if you're out of state, that deposition can be conducted remotely. There's no reason to have you fly in for a deposition. Although in some cases, that might be an issue that the attorneys have to try to work out, to have the court intervene and say, no, we can have it via Zoom. But the attorneys can work that out. The point with this podcast that I wanted to share with you is that to be aware when you have a contract, to be aware of the forum selection clauses. And this also applies to arbitration. And I want to talk a few minutes about that. Oftentimes, especially in different type of business-to-business type agreements, you have a mandatory arbitration clause. Some of them say, I'll give you an example. Any disputes pursuant to this agreement shall be resolved through arbitration through the American Arbitration Association. I'm just giving you that example. There are other places like JAMS as well. It's another company that offers arbitration. It is important to know that, and when you look at a contract, look at it, okay, what if something goes wrong here? How are we going to resolve this? What's the mechanism to resolve this dispute? And it is often ignored. And when I look at it, I said, did you know that you have an arbitration clause? No, I did not know. What is that? So I have to explain what arbitration is. It's a private court that you hire, a private judge, or a service that you hire to manage the case for you. And next week, I'm probably going to have an arbitrator to speak with us and go into more detail about that. But in a nutshell, you're basically paying out of pocket for a private judge and for a company to manage the case. It is not cheap to do that. It usually ends up being a little bit more expensive, in my opinion, than state court, simply because you're paying for additional services that you can get for a filing fee with state court. But there's some benefits to arbitration, and we'll talk about that at another time. But my point is that forum selection clauses should not be ignored. People are being sued from Florida plaintiffs out of state, and it's happening very often. So if you're in a situation where you're an out-of-state defendant and you receive a lawsuit from Florida, don't panic. Like in a state lawsuit, it's a lawsuit. Obviously, it's not pleasant to receive a lawsuit, but there's help out there. There's things you can do, and the first thing you need to do is to contact an attorney. If you do not know an attorney in Florida, contact your attorney where you live. You have a business, most likely you have an attorney where you are. Contact your attorney, say, listen, I got this lawsuit in Florida. What should I do? Your attorney will look at that and probably go through the same analysis that I went through. And I said, okay, well, we need to get an attorney in Florida. Okay, when is he going to look? It's going to go, when is the answer due? When were you served? How were you served? And that attorney will assist you in getting an attorney in Florida. And if you do not have an attorney, then you can contact our office. We can obviously try to assist you or refer you to somebody that might be able to help you. But the point is, do not ignore it because it can have consequences. And you don't want to be defaulted in Florida or anywhere else simply because you did not meet a deadline or you did not contact someone on time. And also do not wait till the last minute to get the attorney to make the contact. If you got served 19 days ago, the answer is due tomorrow, then it becomes an emergency and it really limits your options about what you like to do, as opposed to immediately putting that lawsuit in the top of your priority list in order to handle it as efficiently as possible and as quickly as possible. If anything, any takeaways from today is like, you get sued out of state, it does happen. Understand why you're getting sued, contact an attorney. Also, if you're signing a contract with a company in Florida, take a look at the forum selection clause, take a look at the venue clauses, understand it. If you can negotiate that to be sued or have any dispute be resolved in your state, obviously that's to your benefit if you do not live in Florida. Sometimes that's negotiable, sometimes that is not. And of course, if you need assistance in reviewing a contract, contact an attorney as well. You kind of see my theme here, as I said in prior podcast. If you do not understand a contract, don't sign it, and obviously get legal advice before you sign it to make sure you understand its provisions and that is working for you and your business. This is good for today for episode 98. I truly appreciate you listening to me. If you like the podcast, I hope you do. If you're listening to me for for close to 2 years, please like us, follow us on our Apple Podcast, give us a 5-star review. I appreciate it if you do so. That way that helps the algorithm recommend the podcast to other business owners. If you like to watch the video of this podcast, we're on youtube.com/@RichardSierra. And we also have more podcasts there. Pretty much all the podcasts are in video as well. You can see them on our YouTube channel. If you'd like to learn more about our legal services, my website is floridasmallbusinesslegalcenter.com. If you'd like to give us a call, my number is 866-842-5202. If you'd like to send me an email, my email is rich, R-I-C-H, @richsierra.com. Remember, you can pick up the copy of my book, Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them. It's available on Amazon, Barnes & Noble. You can also ask for any local bookstore as well. Until next week, this is Rich Sierra. And remember that my goal is to help you succeed.